So it looks like it's almost time.
All right, yeah, we've got some more people in the waiting room. Hi, everyone who's there. I hear some birds chirping.
It's funny. Oh, wow. That's weird.
Okay, well, it looks like we have about 17 people in the meeting, and it is 11:01. So I'm going to go ahead and get started with the presentation. And don't anybody worry, we will have a Q&A afterwards. And you can also feel free to write your questions in the chat, and then we can go through them when the main part of the presentation is over. So hi, my name is Silvana Naguib, and I'm a supervising staff attorney at Public Counsel. I supervise the Preventing and Ending Homelessness Project team, which is a project that you'll hear a little bit more about later in the presentation. But what I was asked to talk about today is sort of what's going on right now for tenants during the COVID-19 crisis. There's a lot of people who are facing instability and housing insecurity as a result of job loss or medical issues, lack of childcare due to school closures, and people are really worried about their housing, and some are facing harassment from landlords and are just really uncertain as to what they can expect as this safer at home, basically statewide closure wages on. So I'm hoping to equip everyone with the knowledge and information and the tools to help tenants get access to the services they need, and also just provide some measure of confidence and, if I can be a little bit cheesy, inner peace for people to know kind of, this is what I can expect, this is what's going to happen. And obviously, you know, that's not going to make all of the anxiety go away, but at least people can know a little bit more about what to expect in the future, and not constantly be worrying that they're going to be evicted any day now. So this is about the tenant protections that are available during COVID-19, and we'll cover some of the issues that people are facing, what I call the FAQ, or frequently asked questions that tenants have about things that might be happening to them, and sort of what to do in those various situations. So just kind of as an overview, a lot of people have been talking about this as the calm before the storm. Not a lot is happening right now in terms of legal action for evictions and for housing issues, because the courts are basically closed. They are still marginally open, hearing a few types of cases and a few emergencies, but mostly nothing is going on, and all the cases that were already happening have kind of been put on hold. So tenant advocates like me and my colleagues at Public Counsel and at nonprofits across the city are sort of waiting in the wings. We know that there's going to be a lot of legal issues that come up once things start to reopen and landlords start expecting that rent is going to be paid and filing evictions, and the courts are going to be processing cases. But right now, not that much is happening. It's quiet. But what I want to emphasize today is that tenant advocates are still working and they're still providing services. And so it really benefits tenants to get assistance now, because they can receive advice and counsel to know, okay, this is what I should do. These are the steps that I should take. This is what I should tell my landlord. This is the kind of issue that I'm going to face in my case, and kind of be set up with an advocate and with the knowledge and information that empowers them to move forward with their life. Because one of the things that we're really worried about is that there's going to be a rush. Oh, I'm muting someone. A rush on legal services when things start to reopen. And as I'm sure most of you know, there's already not enough legal services in LA County in ordinary times to serve all the people who need eviction defense and eviction prevention services. So if everyone is seeking those services at once, there's not going to be enough legal services to go around. So that's why we are strongly encouraging people, if they have legal issues, to seek legal assistance now, so that we can kind of get their case up and running. It's much easier to represent a currently existing client than try to start a case from scratch. So right now there is a moratorium on the execution of evictions, and I want to be really clear about all these legal distinctions. So the execution of an eviction is basically when there's an order from the court that says, you know, this person has been evicted, and the sheriff is the one that has to execute the eviction. In practice, basically what happens is that the sheriff comes out and kind of stands there supervising while the landlord changes the locks or pays the locksmith to change the locks, but it has to be done under the authority of the sheriff of Los Angeles County. They have announced they are not executing any evictions right now. The sheriff is not doing evictions, and that includes evictions that were ordered by a court before the pandemic began. So if there was an eviction that was ordered on, you know, March 10th, and, you know, the landlord didn't get around to, you know, submitting the paperwork to the sheriff in order for them to execute the eviction, that's not going to happen right now. There is an exception, and I think it's very important for people to know about this, because I think it really hasn't been emphasized by our elected officials who, you know, to be frank, love to go on TV and say there's a moratorium on evictions. Evictions are not happening. That's true, but there are exceptions, and the exception is an eviction that's related to public health and safety. And we have seen some cases where landlords are claiming that this eviction is necessary for public health and safety because the tenant is using drugs, or the tenant got into a fight on the property, or there's an extermination that needs to happen, you know, pest control, and the tenant isn't allowing, and that's public health and safety. So this is really new. It's a new exception that was invented essentially by the city council and the county when they enacted these ordinances protecting tenants. And so we're not really sure what qualifies as health and safety. And I think it's really going to be up to the judges to determine what fits into this exception. So just be on the lookout that this could happen. It's not the case that there are absolutely no evictions that are going to happen at any time during this period. There are exceptions. So it's also really important to know that there is no what we call self-help allowed, which means that only the sheriff can execute evictions, and landlords can't decide, okay, well, you know, this person hasn't paid their rent, it's been a few months, or I've already filed an eviction, or even there's already been a decision by a judge in an eviction case, so I'm just going to go ahead and change the locks and get this person out. They are not allowed to do that. So we even have cases where, you know, there's an eviction order from a month ago, and the sheriff is not executing that eviction because they've paused all execution of evictions. The landlord is not allowed to take matters into their own hands to get a tenant out of an apartment. So there are sort of a bunch of different ways that landlords may try to engage in self-help. Changing the locks is the most obvious one, turning off the utilities to make it sort of intolerable for the tenant to live there, removing someone's belongings, restricting access like by the front gate or the parking or some other way that that someone can get into the apartment. So it's, and we'll talk about what to do if landlords are trying to engage in this kind of self-help later, but just for you all to know, when tenants ask, or if landlords ask or say, they should know that this is not something they're allowed to do. It's illegal. It's actually a criminal offense. I think it's Penal Code 4318 or something like that. Okay, so the sheriff is not processing eviction orders, but also the courts are not processing eviction cases right now. So what the landlords can do is they can post an eviction notice. They could post a 3-day notice saying 3-day notice to pay rent or quit. You have to pay rent, and if you don't, you got to leave, which unfortunately is very scary for tenants, and a lot of them think they have to move out. But that's really just the first step in an eviction case. So landlords can do that. There's no prohibition in the law against them doing that, and there's no prohibition for them actually filing a lawsuit in the court. Even though the courts are mostly closed and the clerk's offices are mostly closed, most landlords work with attorneys and they electronically file cases anyway, even in ordinary times. So those cases can still be filed. But the thing that is not happening right now, and this is a statewide thing that's coming from the Judicial Council of California, is that the court is not issuing summons, which is the document that has to be served on the tenant to tell them, hey, you've been served with a lawsuit and you have to file a response in court within a certain number of days. And we'll talk about that a little bit later. So it's really the official document that kind of begins the case with respect to the tenant's obligation to come into court and respond and be what we call in the law subject to the court's jurisdiction. So without the summons, the case can't go forward, and the court is not issuing any summons right now. But it's important to know that, again, there's a public health and safety exception. So we've seen a few cases where the landlord will file a case, no summons is issued. Oh, I've been muted. Oh, you guys can hear me again. The landlord will file an emergency motion with the court saying, this is a public health and safety case. You need to issue a summons in this case. And unfortunately, in those emergency motions, a lot of times the tenants aren't present because they don't get adequate notice of the hearing, so they don't have an opportunity to defend themselves. So if you suspect that this is a case where it might involve the public health and safety inspection, or there's some papers that's received by a tenant that talks about public health and safety, this person needs legal assistance immediately, right away, because if they don't act, their rights are going to be negatively affected, and there's a possibility that they actually could be evicted even during this state of emergency, safer at home, court closure, all of that. So please be on the lookout for that. So I want to give some general information. We've been talking a little bit about the exceptions, but general information about the protections that are available to tenants. There's ordinances at both the city of Los Angeles and the County of Los Angeles have enacted ordinances that protect tenants who are being affected by COVID-19. Now, it's important to know that some cities within Los Angeles have enacted their own protections. I think maybe Long Beach. There's a few other cities where their city council has enacted those an ordinance. And in that case, that ordinance would be the one that would control the tenant situation for tenants who live in that city. But if the city hasn't put forward an ordinance protecting tenants, then the county ordinance is the one that would apply. So it's a little bit tricky, but a lot of the ordinances contain the same information. So I think looking to the county is sort of a good guide for what tenants can expect. And then, you know, if there's a particular tenant that needs help, we can sort of do some research as to what, not necessarily we, but lawyers writ large can do some research as to what are the rules that apply. But generally, what these ordinances provide is that tenants can't be evicted for failing to pay the rent if their failure to pay rent is related to COVID-19. So that could be, I lost my job. I couldn't work because I was in the hospital. I couldn't work because I had to take care of a family member who was sick with COVID-19. I had increased expenses that are attributable to COVID-19. I couldn't work because my child couldn't go to school because their school's closed, or their preschool's closed, or their daycare's closed, or, you know, my grandma usually takes care of my child, but I couldn't take my child there because she's 90 years old and she's at risk of getting COVID-19. So if there's any way to create kind of a relationship between the reason that the person is not able to work or otherwise get income and COVID-19, that could be a defense against failing to pay the rent. Now, this doesn't mean that tenants are excused from paying the rent. It means basically they get a grace period to pay it back later. So the rent is still due, but tenants will have up to 12 months after the end of the state of emergency to pay the rent back if they have a COVID-19 related reason for not paying. So what this would look like in practice is, say someone lost their job in March and they weren't able to pay April, May, and June's rent. And let's say they get another job in June, or they start collecting unemployment benefits in June. And then they're able to start paying the rent again for July, August, September, but they still have that issue of that April, May, June rent that they didn't pay. And it's not like, that money could magically reappear. So they will have up to 12 months after the end of the state of emergency to pay back that rent that they didn't pay on time for a COVID-19 related reason. Now, as advocates, we're not very satisfied with that. We're pushing for rent forgiveness, but I just want to tell you guys that that's the state of the law right now. We recognize that for a lot of tenants, it's going to be very difficult for them to pay the rent back ever, because if you lose your job, it's not like you're getting some job where you're, making $200,000 a year and you have all this money. People are still living paycheck to paycheck, so they're not going to have extra money to pay the rent back. But nevertheless, this is the state of the law as it is right now. So after the state of emergency is over and the courts have started to open back up and process eviction cases again, we recognize that a lot of these cases are going to have to be litigated in court and determine, does this person fall into an exception? Can they be excused for failing to pay the rent on time? Is it in fact a COVID-19 related reason that they didn't pay the rent? And this is where things are going to get a little bit tricky, and we'll talk about that a little bit later. We're hopeful that some of these cases will be able to be resolved without going to court. And the Housing and Community Investment Department, which is known as HCID, which serves the city of LA, has said, you can open an investigation with HCID and we'll determine, whether you fall into these exceptions. But realistically, we know there's going to be a pretty decent chunk of cases that are going to need to be resolved by a judge. So that's just something to know. If you have clients or there are tenants that where it's a really kind of clear cut COVID-19 related reason, then maybe they'll be able to resolve it without going to court. But I think there's going to be a lot of cases that are going to kind of be on the margins, especially with the population that DMH serves. I have a lot of clients who are receiving SSDI or SSI or, VA benefits or other benefits. And so their benefits aren't necessarily being cut because of COVID-19. So they still may have the same income that they had before, but now they might have increased expenses, or, there might be other issues that come up that are making it hard for them to pay their rent. So I think it's important to be candid, and those cases are going to be tricky. I'm not saying they can't be won, but it's going to be a little bit less clear cut, and they're not necessarily what has been contemplated by the ordinances that have been passed. Just doing a time check over here. It's 11:18. Okay, we're good. So under the protections that have been passed, there are certain kind of evictions that are not allowed at all. There's what we call no fault evictions. So this is an eviction where, and it's only allowed in certain jurisdictions and for certain types of buildings where there's no real reason that the tenant is being evicted. It's just the landlord has decided they don't want to rent to this person anymore for whatever reason. And it's what's known as a no fault eviction. The number of units where people can have a no-fault eviction has been greatly restricted by a law that went into effect January 1st, 2020, which we're very happy about. But there are still some places where no-fault evictions are legal, and those cannot happen right now in LA County. So those are kind of, there's a complete moratorium on those no-fault evictions. The landlord would have to wait until the state of emergency is over to try to initiate that type of eviction. Now, there's also other reasons why people might be being evicted, or the landlord wants to evict them, that aren't due to payment of rent. There's what we call breach of lease evictions. So, for example, if someone has a lease where it's me and my husband are the authorized occupants, if someone else that is not on the lease is living there, then that's a breach of lease, and I can be evicted for that. During COVID-19, those types of evictions are not allowed if the tenant can show, and obviously this is going to be happening much later in court, that the reason for the breach was due to COVID-19. So let's say, my sister was sick and she had to move in with me because she needed someone to take care of her, because she had COVID-19, then that would be a COVID-19 related reason where I have an unauthorized occupant in my apartment. And let's say she brought her cat with her. My sister does have a cat. But I'm not allowed to have pets in my apartment. So now I am basically forgiven for having breached my lease because it's related to COVID-19. And we're seeing that a lot where families are having to double up. Or for example, let's say someone came to visit, in March to stay for, a week to visit family, and then they weren't able to go home because their home is New York City. And they don't want to go back to New York City where the COVID-19 pandemic is so much worse than it is here in Los Angeles, and it's not safe to travel by plane, whatever. So we're seeing some of those types of issues with families doubled up or people not being able to do what they would ordinarily do. So both, there are two governmental entities that are supposed to be regulating and tracking this. It's HCID, the Housing and Community Investment Department for the City of Los Angeles. For people that are not in the City of Los Angeles, it's DCBA, which is the Department of Consumer and Business Affairs. And if you Google this, you can find their websites easily with phone numbers, emails. They have ways to do online complaints. There's a lot of ways to get in touch with them. So if someone is being threatened with eviction for any of these types of reasons, the tenant should definitely contact HCID or DCBA, depending on where they live, to file a complaint that their landlords are violating these ordinances. Oh, and one little point that I missed, which is that for the City of Los Angeles, there is a portion of units that are rent controlled, and the City of LA has said that in those rent controlled units, rent increases cannot go into effect, even if they otherwise would have been able to do a rent increase during the state of emergency. So if the landlord, sends a notice saying, oh, your rent is increasing on May 1st by 5%, and the tenant doesn't pay that increased 5%, they can't be evicted on that basis. And in fact, they're not supposed to be issuing any rent increases at all. So if the tenant gets a notice of a rent increase, they can also file a complaint with HCID, the Housing and Community Investment Department. Okay, so, we talked a little bit about how the court is not issuing summons, but to look out for, there's some potential issues with exceptions. And we also have some tenants that are reaching out to us saying, I'm getting a notice from the court saying notice of unlawful detainer. Does that mean I'm being evicted? We want to be really clear with people that the case doesn't really start, and your obligation to act doesn't start until you get a summons. So I've included here what a summons looks like, and it has to be stamped by the court. So it's essentially the court telling you, hey, you've been sued. I'm summoning you to the court's jurisdiction for you to respond to this lawsuit. So it's really important to know that it has to be stamped. There's like a little stamp area right here, or sometimes if it's electronically filed, it's issued across the top. So if it's a blank form like this one, it's not valid. So I want to move on now to just doing a time check. It's 11:23. Practical advice for tenants from tenant advocates. And I want to just give shout outs to other lawyers from Public Counsel and Inner City Law Center and Eviction Defense Network and Legal Assistance Foundation of LA, from which I'm pulled a lot of these different pieces of advice for tenants who are facing these issues, and especially my colleagues at Public Counsel. So, what should tenants do if they can't pay the rent? First of all, don't panic. Doesn't help anyone to panic. The tenant should notify the landlord as soon as possible in writing that they're not able to pay the rent because of COVID-19. And we are taking the position that even if it's kind of borderline, whether it's because of COVID-19, the tenant should say that, because if they don't give that notification, they can't get the protection. And it will be up to a judge to determine later whether or not they're actually eligible for that protection. So if it's borderline, we still say it's because of COVID-19, and to keep a copy of the notice that was sent to the landlord so that you could later prove that you gave that notice. And this includes if tenants had to spend extra money on food, supplies, or medicine because of COVID-19 and they didn't have enough money left over to pay the rent. So we're seeing a lot of situations where the places that people ordinarily get food, whether it's school or work, or they go to a senior center every day to get food, and they're not able to do that, or maybe they go to a church, the food pantry, or whatever, because they don't want to leave their house because of COVID-19, or it's not safe, or they're sick, or someone in their household is sick, then they're having to spend more of their money on food, getting groceries delivered, or getting takeout or whatever, just so they can eat, because their normal habits of their life are disrupted. So we are taking the position, and we'll see how it plays out in court, that that's also a COVID-19 related reason for not paying rent. So there's been a lot of debate about what tenants should have to do to prove that their inability to pay the rent is because of COVID-19. So and it varies from jurisdiction to jurisdiction what they're putting in their ordinances. So what we're advocating right now is that tenants keep copies of any receipts, any documents, anything that they can use to show, hey, I had increased expenses or decreased income because of COVID-19, and that's why I couldn't pay the rent. But it doesn't have to be turned over by the landlord. And in fact, we would advocate that you don't feel like you have to turn it over to your landlord unless you really want to, and it's something that's very neutral, like, okay, here's a letter of termination from my job, showing that I was laid off on March 15th. And the tenant feels comfortable turning it over, you can feel free to turn it over if you feel like that's what you need to do for your relationship with your landlord or your peace of mind or whatever. So you could, but if you do, make sure you keep a copy of whatever you sent, because you might need it later. So we talked earlier about how you should notify your landlord. What specifically should you say? There's a form letter at HCID's website, Housing and Community Investment Department. I think it's hcid.lacity.org. But if you Google it, it'll come right up. They have a form letter that tenants can use that basically says, hey, landlord, I can't pay my rent. You can also check out norent.org, which has form letters that it will generate in English and in Spanish. It's been vetted by tenants' rights attorneys. We think it's really good, and we're highly encouraging people to use this form letter to notify the landlords that they are not going to be paying the rent. Do not tell your landlord that you, that's a typo, it should say plan to pay, that you plan to pay with any specific funds you will receive, like a stimulus check or unemployment, because you don't know what's going to happen in the future. You don't know whether you're going to have some other expense that's going to come up that's going to be even more urgent than paying your rent, or someone you love could end up in the hospital or whatever. And so we don't want, there to be an expectation that, the tenant promised that when they got their stimulus check, they were going to turn it all over to the landlord, and now they didn't, even verbally. Now, if you get the money and you can pay, great, then you can pay your landlord. But we don't want people making promises to pay in advance. What if I can only pay part of the rent? That's great. Any amount that you can safely pay, we recommend people go ahead and pay, but make sure to make a budget of expected expenses and determine how much money is available to pay the rent, because nobody should be going without food or essential supplies in order to pay the rent. So, maybe you make a determination, in terms of all the food I have to buy and extra expenses, I can only pay $200 a month in the rent, but I can safely pay that. So tenants can go ahead and pay it and make sure that they get a receipt or some other kind of documentation that they've paid it. If you're putting a money order in a Dropbox, take a video of yourself putting it in a Dropbox, just to keep evidence of the fact that you did pay, because you don't want your landlord coming back later and saying you didn't pay money that you actually paid. So it's especially important to keep track of rent that was paid. And in fact, these are good practices all the time. So, you can get the word out on the street about that. Okay, landlord harassment. We're seeing a lot of tenants, especially ones who already were having issues with their landlord before all of this, where landlords are constantly texting and emailing saying, you need to pay, when are you going to pay? Did you get your stimulus check? You need to pay me, I need the money, I need to pay my mortgage. Some landlords are struggling too, especially the smaller landlords, what we call the mom and pop buildings. So what we recommend is you ask your landlord only to communicate with you via email and text, because it can be very stressful to get those calls. And if your landlord calls, you don't have to pick up. And when they text and email, you don't have to answer. You can set aside time, every 4 or 5 days or once a week to say, I'm not going to look at any emails and texts from my landlord. I'm going to do that once a week on Fridays. I'm going to look at whatever he or she sent me, and I'm going to send one response if necessary, and then that's it, just to kind of reduce your own stress. And then when you do that, when you do check those emails and texts, keep screenshots, because you're going to want to maintain a record of any communication. And if you're going to say your landlord was harassing you, you're going to need proof later. If the harassment is persistent, then you can file a complaint with HCID, the Housing and Community Investment Department, about your landlord's behavior, and they might be able to reach out to your landlord and tell them to cut it out. So one issue that we've seen is repayment agreements, that tenants are being given these documents that says, I agree to pay X amount of money by X day, and this is, my repayment schedule that I'm agreeing to. Do not sign repayment agreements. You're not required to sign. You can't be evicted for refusing to sign, and it doesn't benefit the tenant in any way. It really can only hurt the tenant to make a promise in advance that they're going to pay and when they're going to pay. Of course, you can pay. You can pay it all. You can even pay on the schedule that the landlord proposes. But we are advocating that people not agree in advance to do that, because if you don't, for whatever reason, whatever happens that may make you unable or unwilling to do that, then that could be a separate cause of action against you for failing to meet that agreement that you agreed to make. So don't do it. That's our advice. I so rarely I'm willing to give very clear, unequivocal legal advice, but this is one of them. Don't sign a repayment agreement. Okay, utility issues. My landlord turned off my utilities. We're seeing this a lot where people are like renting a room in a house, or they rent a back house on a property, and so the landlord controls the utilities because utilities are included as part of the rent. This is tenant harassment. It is known as what's called a constructive eviction. They didn't actually evict you, but they basically did, because you can't be expected to live somewhere with no water. Unfortunately, some landlords are getting desperate and resorting to illegal methods. You should file a complaint with the health department right away. In the city of LA, file a complaint with HCID. In the county, Department of Consumer Business Affairs, DCBA. And probably contact a lawyer right away. We've sent, we and other organizations that represent tenants have sent a number of demand letters to landlords saying, hey, this is illegal. You need to turn the utilities back on ASAP. And you can also try reaching out to the utility company. That has worked as well, but sometimes it doesn't. Bank statements. We've heard some reports of landlords asking for bank statements. As I previously discussed, tenants aren't required to turn over proof of their inability to pay, like a bank statement, although we are advocating that people keep it just as kind of, insurance, just in case they do need it, or the courts do require it. But bank statements, this is again one of my rare unequivocal pieces of legal advice. Don't turn over your bank statements. These are private. They contain a lot of personal information about your spending habits, and we don't think tenants should have to turn over this type of information, and we don't want the landlords to be in the position to scrutinize your spending, analyze, oh, hey, they went to Ralph's and they spent $500. Why do they need to spend $500 at Ralph's? Or, they did online shopping at, Toys R Us. I guess Toys R Us is bankrupt, but you get the idea. So don't turn over bank statements. If bank statements are the only thing you have, keep it for yourself, but don't turn it over to your landlord. Wait, I went back. Okay. What if the person's inability to pay rent is not because of COVID-19? So this is a little bit of a tricky scenario, because the protections that have been put in place by the city and the county are only if it's related to COVID-19. But there's a lot of creative arguments that can be made related to COVID-19. So let's give an example. Let's say someone had their disability benefits cut off in January because Social Security says you're no longer disabled, so we're cutting off your benefits. Well, that's not related to COVID-19, but let's say the person actually isn't disabled and they wanted to go out and get a job. Well, can't get a job right now because nobody's hiring and there's a pandemic and you're supposed to stay at home. So arguably, even though they didn't lose their income because of COVID-19, their inability to gain more income by working is because of COVID-19. So there's some kind of, creative scenarios that we can come up with to argue that tenants should be forgiven for failing to pay the rent. We don't know how these cases are going to be handled in the future. Right now, the court isn't issuing summons. The sheriff's not executing any evictions. So our best recommendation is seek advice and counsel from a lawyer. Keep any documents that you have and don't sign a repayment agreement and don't move. We'll get to the moving issue later. Okay, and if you get any documents from the court, seek legal advice. What if I was already being evicted before COVID-19? This is of special interest to me since, I'm a tenant advocate all the time. And so I have a lot of clients that were already having issues and facing eviction before any of this happened. You need legal help immediately. Even if you don't already have a lawyer, then you should try to get one. And we'll have more information about how to seek legal assistance later in the program. The rules about, and the reason you need a lawyer, even though the court is not doing anything right now, is that the rules about pre-existing cases are complicated. And it really depends when your case was filed and whether you were served with a summons and when you were served with a summons as to whether you're required to file an answer, which is like how you kind of respond to the court and enter the case, and when you were required to file it and all of that, because between March 15th and April 15th, the rules changed like 10 different times because there was orders from the governor, there was orders from the Judicial Council of California, then the LA Superior Court. So there's been a lot going on. So if something happened in that period with respect to someone filing an eviction against you or serving you with a lawsuit, you need a lawyer right away to determine, do I have to respond? If so, when? And to take action, even if it's late. So we have some clients that we're finding out, according to the rules, they should have filed an answer by April 22nd. Well, better late than never, because the court's not processing evictions right now anyway. So we don't want anyone to throw up their hands and say, oh, it's too late. I didn't act when I was supposed to act, so I guess I'm just going to give up and move. No, there's always a benefit to having legal representation because lawyers can try to leverage the rules as best we can in the tenant's favor. And frankly, because the court is not processing cases right now and the rules have changed so many times, we expect that courts are going to be somewhat forgiving for people who didn't act when they were supposed to act, because it's really confusing, even for lawyers. The cases that were already set for trial have been taken off the calendar and they're suspended. They're in limbo. And we expect once the courts open back up, the court's going to start setting trial dates again, but we don't really know when that's going to happen and we don't know how long it's going to take. And that's just my caveat again to watch for the public's health and safety exception. Because let's say you had a pre-existing case that was just about payment of rent, had nothing to do with public health and safety. And then let's say something happens where the landlord thinks, oh, hey, now I can argue that this is public health and safety because, this person got into an argument with another tenant, or they allegedly threatened the manager. Now I'm going to go before the judge and say, hey, we need to speed this case up because of public health and safety. So just watch out for that, even with pre-existing cases. When will the courts reopen? I have been asked this question by many people, including lots of reporters. Right now, they are scheduled to reopen on June 22nd, which is when the court order that suspends most types of cases expires. But as we've seen, it could always be extended. It could be shortened. We don't really know. And most likely, if I had to guess, I would guess that there will be another order that will be entered so that it kind of opens gradually. So maybe they'll say, okay, we're not going to handle all types of cases, but we're expanding it from these 10 things to now we're going to do these 20 things. So if I had to guess, I'd guess that's what will happen, but we really don't know. And we don't know whether evictions will be included in, whatever the court starts doing when they start reopening in that first wave. So this doesn't mean that tenants should ignore documents from the court, although it may take a long time for the courts to kind of process everything once they start doing cases again. Tenants still need to protect their rights and take action, and it is beneficial for them to do it sooner rather than later. We have tenants that want to move. They want to know, should I move? Should I just move? I got a notice from my landlord, or I got papers from the court. I just want to go ahead and move. Our answer is no. Do not move unless you have somewhere else to go that is as good or better than where you are now. And this includes living conditions, the amount of rent. Are you placing your family at risk by being exposed to people who are still working and might be exposed to COVID-19? Evictions are not happening right now. So it's not beneficial for people to move if they're putting themselves in a worse position than they would have otherwise been. You can't be evicted right now unless there's a court order, which meant you lost your eviction case or you signed an agreement to move. And there's been a determination by the judge that this eviction has to happen now because of public health and safety. That's hopefully going to be a very small number of cases. So don't move if it puts your family at risk. Now, if you find another great place that you can afford that doesn't put your family in at risk, great, go ahead and move. But for the vast majority of people, they should stay in place. My landlord is threatening to lock me out. We talked about this a little bit before. Here are the steps that I encourage people to follow because your landlord is not allowed to engage in what we call self-help. So every time you leave the house, take your cell phone, take your keys, and take a recent utility bill that's showing your address every time you go anywhere. If the landlord changes your locks while you're out, call the police right away. Tell them your landlord has illegally locked you out. You're waiting outside with proof that you live there. And then just wait until the police get there. Don't engage any further. And we've had a few cases where the police haven't done what they should and haven't, made sure that people got back to their apartments. But for the most part, the police will tell the landlord, hey, look, you can't do this. You have to follow legal process of eviction and make them let the tenant back in. We are seeing some issues that are related to repairs where people are having conflict with their landlords because the landlord wants to do repairs and they don't want to have workers in the apartment because they don't want to be exposed to COVID-19. Everyone's supposed to be practicing social distancing and they don't have anywhere to go because people aren't going to work, they're not going to school, you can't go visit your mom or your friend because everyone's practicing social distancing and you don't want to just walk the streets because that's not really safe either. So we're asking that landlords defer all non-emergency repairs and maintenance until the state of emergency is over. And I think there might be some legal rule to that effect, but I have to confess, I'm not sure. In general, your landlord has to give you 24 hours notice of any entry or needing you to leave your apartment. This gives you an opportunity as the tenant to say, hey, look, I don't want anyone in my apartment right now. I don't have anywhere to go and I'm practicing social distancing, which I'm ordered to do. So please don't come unless it's an emergency. You can ask your landlord to reschedule. Maybe there's a time when you know you're not going to be there anyway because you're going to go grocery shopping or you have to go to work for some people who are still working, and ask that the workers wear masks and gloves if it is an emergency and they do have to come in, so that you can make sure that there's no spread of disease from people entering your house. You can also try calling HCID or DCBA to raise a complaint with them about this issue. There's been a couple issues of people wanting to show their unit to prospective tenants. If you're at the house, they need your consent in order to show a unit to prospective tenants during COVID-19, according to, in the city of LA, according to Mayor Garcetti's order. So if you don't want to consent, you don't have to, and you can tell them they have to do a virtual showing instead. So my final part of the presentation, I'm going to try to wrap this up quick so that there's time for questions. Legal assistance for tenants. Here's how to get it. If the case is filed at the Stanley Mosque Courthouse, or would be filed at the Stanley Mosque Courthouse, and it covers East LA, Hollywood, Koreatown, downtown, the northern part of South Central. It covers a lot of LA. The Shriver program is providing self-help for people, advice and counsel, helping them file answers, and here's how you can get in contact with them to get remote help. And people are assigned lawyers through that program, not everyone, but a lot. Then there's the Lawyers Preventing and Ending Homelessness Project. That's what I do and my team. And it's a countywide project that's funded by LASA. There are 7 different legal nonprofits that provide legal services to people at risk of homelessness. We serve all the courthouses. It's a little bit tricky because you can't make a direct referral to us or our program. They have to come from the prevention funded CES agencies by service area. And I have some links here to try to figure out what the appropriate agency would be. So for example, my team serves South LA. We get the vast majority of our referrals from HOPIX, who is the prevention funded agency for families, for SPA 6. And so they send us referrals for people who are being evicted. The bonus is, I'm sure a lot of you already know this, but if you don't, once the tenant has been assessed by this agency, they might also be eligible for financial assistance to pay the rent. So we've had clients who, let's say they lost their job and they were able to get another job, but they can't pay the back rent. They could get assistance to pay that back rent from this agency and legal services from us. So it's a package deal. Other legal resources are just listed on here. You can peruse those at your leisure. And when it comes up, Eviction Defense Network is doing remote advice and counsel. BASTA, there are some in-person weekly clinics that aren't happening anymore, but they're providing advice remotely. So you can reach out to them. Can public counsel represent my client? Maybe. Generally, we don't accept direct referrals, and I have a description here about how we get our cases, the Shriver program, and the Preventing and Ending Homelessness Project, which are described on previous slides. So there's a referral process that goes through other organizations in order to get to us, and tenants cannot self-refer. Questions? There are no stupid questions. I am ready for questions. I'm going to try to figure out how to mute, unmute. Oh, everyone's been unmuted.
Yeah, so Dave has all that information.
I have a question.
Yes, please introduce yourself. I can hear you.
Okay, my name is Julia. I'm in SPA 4, and my question is, I know you had recommended the HCID for people to go to if there's issues in LA City. Is there any other body that outside of LA City but within LA County that people can go to for complaints regarding landlord increases or things like that?
Yes, so two things. One is there is the DCBA, the Department of Consumer and Business Affairs, which is for all of LA County. Can you guys hear me?
Hello? Yes.
Okay. So so DCBA is one body, and then you can also look to see if that specific city has a body that governs rents. You could look at something like rent board or rent control for the name of that city. Like for example, I know the city of Gardena, which we represented a bunch of clients, they have their own rent mediation board that deals with complaints, issues, conflicts between landlords and tenants. But I would say, start with DCBA, Department of Consumer and Business Affairs, if it's not City of LA.
I'm originally from Houston. No. I live in Los Angeles now, and I have been living in Los Angeles for about 12 years now. So within our organization, we hit the streets of Skid Row, we house people, we just get in there and just really try to do our best and get people from wherever they are to wherever they're going. So with all the outreach that we do, I take teams and teams of people out into the streets of Skid Row, like direct hand-to-hand contact. And since this, it's really had a different impact on my day-to-day job. Like, honestly, it's been hard to get supplies.
I'm sorry, sir. Are you on this call? Are you asking a question?
People really,
I think maybe someone else is on another call.
So they're in the shelter, but they do have jobs. So a lot of those have now been forced to stand in the lines to get food, but the food has been scarce. Like the donations that we.
Okay, I've muted everyone. If you want to ask a question, can you type it in the chat box? Or can you tell me in the chat box that you want to be unmuted?
I did.
Okay. Okay, I've unmuted everyone. Does anyone have a question that they would like to ask?
I'm also seeing so many people band together and so
No, this place is over the top. Lovey-dovey, skipping down the street, twirling. I was jumping on over.
All right, I've just muted someone.
Can you hear me?
Yes, I can hear you.
Great. This is Xavier from SPA 4.
Hi.
Hi. I wanted to know if there's a fee of service in regards to the services that you provide for, clients who are about to be evicted.
I'm sorry, can you repeat the question? I couldn't hear you.
Is there a fee of service that you provide in regards to the services that you provide for clients who are about to be evicted?
Oh, that's a really good question. No, our services are free. And both of the programs that I described in detail in the slides, the Shriver program and the Preventing and Ending Homelessness program, those are both free programs for people who are indigent. So I think it's 50% of AMI and less, which is quite a bit. And then some of the other organizations that I described in the last slide, like the Defense Network and BASTA, they do charge a very low fee for the clients. But there are plenty of free services that are available. Whether there'll be enough free services for everyone who needs help when the courts, start to reopen, probably not. But that's why it's a good idea to seek services sooner rather than later.
One more question.
Yes.
Does it matter if the client happens to be undocumented?
No. So that's a really good question. And I'm going to make a note to add that to my presentation before I send it out, because that's a really good point. We serve undocumented clients, and most of the organizations will serve undocumented clients, and it does not matter whether they are documented or undocumented in order to be eligible for the protections that have been put in place by the city and the county. Now, there are a few legal services organizations that are actually prohibited from representing undocumented clients because they receive federal funds. Thanks, U.S. government. But what we do in those situations is they refer those clients to another organization that can. So for example, in the Preventing and Ending Homelessness Project, Legal Assistance Foundation of Los Angeles, they're not able to represent undocumented clients because they receive federal funds. So they refer those clients to us because we can and do.
And do those federal organizations or those organizations that receive federal funds, do they report that they have been referred to, that those clients have been referred to another organization?
To who?
If, for example, if the organization that's receiving federal funds receives a request from a person who happens to be undocumented, do they report the referral to the federal government? Because
no.
Okay, good.
No.
That's it.
Thank you.
Thanks.
What other questions do folks have? Okay, Paula is asking a question in the chat. Can a related reason for inability to pay or alleged breach of the lease be aggravation of a pre-existing mental health condition which was made worse by COVID? That's really interesting. I don't know the answer to that. And I think that's going to be an interesting area of law to explore once the courts start having to litigate these cases. But I think it's certainly a decent claim to make, and I would feel comfortable arguing it. I also would note that one of the members of our collaborative in the Preventing and Ending Homelessness Project is Disability Rights California. And often we get cases where the defense would be essentially the reason that this person is being evicted is related to their disability. And so there's kind of a reasonable accommodation claim that needs to be made with respect to the breach of lease. And so, you know, sometimes we handle those cases ourselves, but we're also able to refer them to Disability Rights California, which has a ton of expertise in disability related housing issues. So if I were to get one of those, that's probably what I would do, is send it over to Disability Rights California, DRC, for them to handle it. All right, it's 11:54. We're 6 minutes before the projected end time of the presentation. Does anyone have any other questions? I have nowhere to be, so feel free to ask your questions.
Oh, I have another question. So I'm wondering, are there any tenant services that are available that people can, we can like refer our clients to during this time? I know, what is it called? The Coalition for Economic Survival used to have a regular 2-time-a-week legal clinic. Are there any other services that people can go to like that available now?
Yeah, well, actually, so there's a couple different things. One is that Coalition for Economic Survival is now providing advice and counsel via email. And on one of the last slides of the presentation, I have their, let's see, I have their information. Where are they? Yeah, contact ces@earthlink.net. And it has, and if you go to their website, it has that too, and a description of what should be included in the email. So they're still working. So that's one thing. But then the other thing is that I'm strongly recommending that folks go to the prevention funded agency in their SPA, their service planning area, because this is supposed to be kind of the hub for all different kinds of services that they may need, whether it's, you know, mental health treatment, or they, you know, they need diapers for their kid, or they're having issues with the rent, or they need legal services. And I know that a lot of these agencies are starting to provide services remotely. So for example, the agency that we primarily partner with, HOPIX in South LA, they have set up an email address, what they have on their website, which is like prevention@hopix.org, where tenants can reach out and get contacted by someone so that they can get assistance. So, and the nice part about that is that then if there's other services that they need, that's a hub as well, and not just, you know, access to legal representation. I see Amanda's question. What is the new LA County program that came out to protect tenants and give them representation, or at least counsel and advice? I don't know, Amanda. Maybe you know something I don't know. If you want to follow up in the chat or talk even, I'm not sure which program you're talking about. A question from Simone is, what veteran-specific legal services that you provide? Well, our team, the Preventing and Ending Homelessness Project, and other similar teams at the other legal nonprofits, we provide all the same services to veterans who are facing potential homelessness. We receive a number of referrals from organizations that serve veterans, and so we provide those same services, but it might involve, you know, some more complicated benefits issues potentially, and then we will probably try to partner with another organization or see if our veterans team, I see Amanda and Paula on the call, could help them out. So we're not a veteran-specific program, but we do serve veterans. Amanda says, I heard legal aid organizations were funded by LA County to assist around 800 households from now until October. I mean, this could be related to the Right to Counsel program. It's possible that there have been developments in the last few days that I don't know about. So I'm going to go for the scoop when I get off the call. All right, well, it's 11:58. If anyone has any questions, I am ready to take them. But otherwise, I will end the call. Going once.
Thank you, Silvana. This is Lisa with DMH. Thank you for presenting today.
Thank you everyone so much for being here. And I'm going to type my email in the chat. Feel free to reach out. Thanks, everyone.
Thank you.